Well, hello and welcome to this Farrar's Building webinar. I see we've got 74 people have joined us, so we'll make a start. It's wonderful that so many people could join us for this particular webinar. Our topic today is recent developments in the law relating to credit hire, particularly impecuniosity. My name is Tom Emsley-Smith. I'm a junior at Farrar's. And I have a mixed civil practice, so a lot of my cases do involve credit hire, either on the faster multi-track or on the small claims track. Just as an indication of where we're going today, to briefly outline the talk. Firstly, I'm going to start by recapping the law on impecuniosity, the basic principles, and then we're going to look at pleading and proving impecuniosity and some of the recent developments that have provided a bit of guidance on that. And really that's the main thing that I want to look at today. A recent case called Dirier and Bojaj and the new practice direction and the sort of guidance that gives as to the level of detail that claimants should provide in the witness statements and pleadings. And what can be drawn from those cases on that particular subject. So that's what we're going to spend most time on. Then briefly at the end, looking at credit cards and to what extent claimants should be expected to draw on them. And then even more briefly, looking at how all this affects taxi drivers and a recent case on fundamental dishonesty as it relates to impecuniosity. What I say in all webinars, it's the same sort of setup if you've attended any of these before. There's a Q&A box either at the top or the bottom of your screen. So if you have any questions that arise during the course of the webinar, please do just feel free to type your questions in the Q&A and I'll return to them at the end. So as you know, impecuniosity involves several different things. Usually it's a question of how much money someone has in the account, but obviously it depends a little bit on the car that they're driving. If it's a particularly expensive car, then maybe someone with a bit more money wouldn't be able to afford to hire a vehicle. This is a crash that happened in Japan, and it involved 8 Ferraris, 3 Mercedes, and a Lamborghini. So the insurer of the car at the front has had an absolute nightmare. So not too many cases that you'll have to deal with involve that kind of thing, but there we go. So to go through the basic principles, first of all, before we get into the recent developments, as you'll all be aware, when we're looking at impecuniosity, we need to first be aware of the exercise that the court is expected to undertake in respect of ascertaining the basic hire rate to be awarded to the claimant in credit hire cases. So we need to look at the stripping out exercise. This was first expressed in the case of Dimond and Lovell. In that case, Mrs. Dimond had signed up to a credit hire arrangement, and the House of Lords said that in doing so, Mrs. Dimond acted reasonably. They said, I'm sure that any one of your lordships in her position would have done the same. She cannot, therefore, be said not to have taken reasonable steps to mitigate her damage. Now, the problem was not that she had failed to mitigate, but that her contract, the credit hire contract, included the cost of hiring the car, but also other services that are irrecoverable in law. So a charge for the extension of credit, the claims management that the credit hire company would be doing, negotiating with insurers, and cost protection. So she wouldn't have to pay the legal costs of any adverse cost order. So these are all charges built into the credit hire agreement that aren't recoverable in law. And the problem is, how do we estimate the value of these additional benefits and strip them out so that all she's being awarded is the cost of hiring the vehicle rather than the full package? And the answer in Dimond and Lovell was that it's the difference between the credit hire charges and the charges for an ordinary hire company. And Ms. Dimmond would only be allowed to recover the charges for the ordinary hire company. Now, the point about it being not a case of the claimant failing to mitigate her losses is one that not everyone appreciates, and many judges don't appreciate that either. So it's not that someone acts unreasonably by going to a credit hire company. It's the fact that the court has to strip out those additional benefits, and that's what the basic hire rate exercise is for. And that's an important point to appreciate because it helps us appreciate why the burden of proof is on the claimant to show that they are impecunious. So as you all know, the impecuniosity exception is just that, it's an exception to that general rule that the claimant doesn't get to recover the full credit hire charges. And it's where an innocent motorist is unable to pay for a hire card. Then they act reasonably in recovering the full charges because they can't do anything else. Impecuniosity was defined in that case as the inability to pay car hire charges without making unreasonable sacrifices. That was Lord Nichols at paragraph 9. So it doesn't necessarily mean that they have absolutely no money in the bank account. It just means that if they paid the hire charges and they would have to sacrifice something that they would otherwise have spent the money on, then they're said to be impecunious. The final case, just in terms of the very basic principles, is that impecuniosity, as again, I'm sure you all know, it does not just go to the rate of hire, it goes to the period of hire. So in Zurich and Umergy, the principle was that a person relying on impecuniosity to justify the period must plead and prove that. So if they're saying that the reason that they hired for so long was that they couldn't afford to repair or replace the vehicle any sooner, then the burden of proof is on the claimant to prove that in the same way as it relates to rate. So whistle-stop through the very basics. The questions where impecuniosity is in issue really just involve an analysis of people's bank statements. But obviously there can be a bit of variety in terms of how much they have to have. For example, you might have someone who's living pretty much hand to mouth, doesn't have very much money in their bank account, but they're driving an old banger. So maybe it wouldn't really cost very much to hire a replacement vehicle equivalent to their own from a mainstream company, and they might just have enough funds to do so. Whereas someone else might have a lot of money, but they're driving a very expensive car. So this is Ty Dolla $ign's car. He's a rapper. This is his blue Porsche and he's banged it up. Now, Ty Dolla $ign, is he impecunious? Probably not. But if he had to hire a replacement Porsche equivalent to his own, then maybe he wouldn't have enough money to do that. I don't think many judges would be particularly impressed with that suggestion. But it's a possibility if he's having to hire a replacement for a very expensive car that's equivalent to his own. So really a lot of cases involve looking at these questions, how much needs to be pleaded or set out in a witness statement, and how much explanation should the claimant provide? Because quite often it's pretty clear on the face of the documents how much the claimant is saying that they had in their bank accounts. And often cases will turn on grey areas, things that the claimant hasn't provided very much explanation of, questions that remain on the bank statements, entries that look as if there are other bank statements that haven't been disclosed, unexplained transactions, and documents that haven't been disclosed. Things that it's more to do with what the claimant hasn't said rather than what can be seen in their bank statements. So very often burdens of proof are quite important. How much is the claimant expected to explain, and in what level of detail are they expected to show that they are impecunious and they couldn't afford to hire? Well, the first case to consider that really grapples with that issue is Zurich and Urmagi, as I mentioned earlier. That issue was considered in terms of what the claimant needed to set out in terms of showing that they couldn't afford to repair their car any sooner. The starting point, the Court of Appeal said, was that Practice Direction 16 requires the claimant to plead any facts relating to mitigation of loss or damage. Now, that is a funny practice direction because usually it's for the claimant to set out their stall and it's for the defendant to attack. Whereas this practice direction seems to be suggesting that the claimant has to anticipate ways that they could have mitigated their losses and to set them out and to suggest ways that they should mitigate their loss. But the Court of Appeal said that in credit hire, that is to be expected because a credit hire claim is a claim for expenditure to mitigate the primary loss, which is the loss of use. So the claimant is basically saying, I had a loss of use of the car and I had to spend this money to mitigate that loss of use by getting another car that was equivalent to it to enable me to do the things I would usually do. And so it's for the claimant to say why that was reasonable. To spend that amount of money on a credit hire vehicle. So in such a case, the claimant should plead his case as to reasonableness, including any assertion of impecuniosity. And the Court of Appeal said that there is no doubt a grey area about how much needs to be pleaded and proved to establish reasonableness before the evidential burden shifts to the defendant to show that the expenditure was unreasonable. So we have this grey area. If the claimant provides some evidence that they didn't have very much money, how much do they actually have to show to the court? What kind of evidence do they need to be expected to meet before the burden shifts to the defendant to say, well, actually, no, that's not right. You could afford this, couldn't you? So the first recent development to look at is one that I think clarifies that grey area to some extent. And that's the new Practice Direction 16, paragraph 6.3. This came into effect on the 6th of April 2020. So any claims being brought now should follow this practice direction. And in fact, many claims have been doing this. For a long while, but not every claim. So this is the standard that the claimant is expected to meet now when they're pleading the particulars of claim and setting out their claim at the outset. It says that what needs to be included in the particulars of claim is the need for the replacement vehicle, the period of hire claimed, the rate of the hire claimed, and this is the significant bit, I think, the reasonableness of the period and the rate of hire, and impecuniosity. And then paragraph 6.4 says the relevant time is at the start of the hire and throughout the period of the hire, and the obligation to state the matters there set out includes an obligation to state relevant facts. So the CPR now has an expectation that the claimant will set out the facts, not just the assertion. That show that the period of hire and the rate of hire were reasonable. The second development that goes some way to clarifying this issue is this recent case last year called Dirier and Bojaj, and it really touches on the same matters. In that case, the claimant was required to submit a reply to the defense, setting out all facts in support of impecuniosity. And the order said that if he failed to do that, he'd be debarred from relying on impecuniosity. And I'm sure that you're all used to seeing those kinds of directions that some courts like to issue. But the claimant failed to serve a reply compliant with that order in time. So I think from memory, it was a couple of days late. And the main issue, so the claimant had to apply for relief from sanctions in order not to be debarred from relying on impecuniosity. And the main issue was one about whether signed for first-class postage was a valid method of service within the CPR. That doesn't really concern us here. What's of interest to us here is that the Court of Appeal, when considering the third limb of the Denton test, so all the circumstances of the case, looked at what was set out in the reply and considered whether that actually complied with the substance of the order. So what the claimant had said was simply a bald assertion along the lines of, I was impecunious because I couldn't afford to hire a car, and didn't really give very much more detail than that. And the Court of Appeal, when looking at the third limb of the Denton test, said that, in fact, it's a highly relevant circumstance that the reply doesn't actually comply with the substance of the order. They said that the claimant hadn't actually set out the basic information that it needed to set out in order to be in compliance with the order for reply to the defence. What the claimant had argued in front of the Court of Appeal was that there's a difference between pleading the case and then the evidence that is required to support it. So what they were saying was that in the particular claim, you just need to set out the case that the claimant has to meet. So the claimant's case is, I was impecunious. And then at trial, you have to produce the evidence that shows that you were impecunious. And the particular claim doesn't need to go into that level of detail. It's with the disclosure and the evidence that you hear at trial, that's where the detail is fleshed out. The Court of Appeal didn't really like that. They disagreed with that submission for three reasons. First of all, they said that the wording of the order was quite clear, that it required the claimant not just to set out the assertion of impecuniosity, but to set out all facts in support of impecuniosity. Secondly, they said this, well, there's a quote there. They said, the claimant's not entitled to advance a rubbishy case in stages, presumably in the hope that by the time the trial came on, there was a commercial imperative on the part of the respondents to settle the case. So pretty strong words and pretty good for defendants. Something that if you're acting for a claimant, you'd have to sit up and have a look at. And then thirdly, is the position of the defendant. The defendant's entitled to know the case that they have to meet. And if there's significant facts that support the assertion of impecuniosity, the claimant should bring them forward at the outset of the litigation. I just wanted to set out three quotes from the judgment that are quite helpful in understanding the level of detail that the Court of Appeal was saying should be expected of the claimant when they're pleading their case. Firstly, parties to civil litigation need to make clear the important elements of their respective cases at an early stage. Gone are the days of ambush and keeping important points up your sleeve. Second quote, if a claimant delays providing critical information, particularly where they've been ordered to provide it by way of an unless order, that delay adversely affects the other side's ability to take a view about the strength or weaknesses of the claim they face. And District Judge Walder made the unless order to avoid the appellant simply coming to court at trial and saying, I didn't have any money. For the reasons I've set out at paragraphs 48 to 54 above, the reply merely perpetuated that stance. So this is a very helpful case and one that everyone should read, really, if you're dealing with credit hire. If you're acting for a claimant, it will give very helpful guidance about the factual matters and the level of detail that you should really provide at quite an early stage. So the things that you should include in the particulars of claim, and especially in the witness statements as well. And if you're for a defendant, it's very worth reading as well. because it shows a very successful attack on a fairly undetailed reply to the defense that was ordered by the court. So looking at how this is actually going to affect practice, the first and most important point is, as I've been saying, claimants need to set out actual facts supporting impecuniosity rather than just bold assertions. So in most cases, that's likely to involve some basic figures. So we're all used to seeing template pleadings and witness statements that just say I was impecunious because I couldn't afford to hire a vehicle after my outgoings had gone out. I think after Dirier and Bojaj, if you're for a claimant and you have one of those witness statements, I think you run the risk of that not really being enough information. The case seems to suggest that some basic figures like how much was available in the main bank account at the beginning of the hire period and how much was it available at the end would be very helpful information. Credit card limits and totting up the income in a typical month and the expenditure in a typical month. That would be very helpful information and would help the judge to conclude that the claimant's either impecunious or not. Unusual or particular features of that claimant's income or expenditure or their savings, in my view, should be pleaded. So if you have a claimant who, for example, had a savings account, but they couldn't touch that money because they were going to spend it on, I don't know, say building a pond in their garden, following this case, it will not be looked upon as very impressive by the court if that information only comes out at the first time at trial. So there is an expectation that if there's something particularly significant as to why the claimant couldn't spend the money they have, you should raise that and you should say that either in the pleadings or at a very early stage, so that you can't be accused of ambush. Further practice points, just on more procedural matters. Failure to comply with the guidance or the standards referred to in this case, it's not going to lead to a strikeout of the claim. It won't lead to debarment except if the claimant is in breach of an unless order. So you need to look at the terms of the unless order to see if the claimant's debarred. But what defendants can argue, in my view, and it's perhaps a bold argument to make, but certainly one that's available, is that a very vague reply, one that's in the terms of I simply couldn't afford to hire a vehicle, with no more detail than that, is not compliant with an order that tells you to set out all the facts. And that is an argument that can certainly be made on the basis of the reasoning of the Court of Appeal. In paragraph 54, they say very clearly that they didn't consider that kind of pleading to be compliant with what was required by the order, which asked for facts. A third implication is that some judges may apply the burden of proof more stringently if they're aware of this case, because what it would make it difficult for the claimant to do is simply provide the bare minimum of explanation. And if there are questions to be answered, simply sit back and say, well, I've provided some information and it's for the defendant to show that I'm not impecunious. This case will allow defendants to argue that the claimant needs to be forthcoming with most of the relevant information. And if they don't do that, then they might have failed to discharge the burden of proof. So I'm not saying that that's the that's the approach that all judges will take. And obviously every case turns on its facts, and it probably depends a lot on how low the funds are on the face of the document. But in those those cases where it could go either way, and there are maybe some documents missing, or there may be some odd entries, then judges might be a bit more willing to say, well, the claimant has a basic duty to be providing the information to the court in the first place. It's quite likely that a failure to provide helpful information, helpful facts, might be relevant to costs, because if a claimant looks like they're pecunious, and then it emerges at trial for the first time that there's some reason why they couldn't spend their money, on the basis of those comments that I read out, it would be very easy for the defendant to say, well, we've been preparing the case on the basis that it looks like he has plenty of money, and then we weren't to know that actually there's this extra information and that emerges for the first time. So the claimant shouldn't be entitled to their costs. So you can certainly see costs arguments being raised along those lines. So claimant advisors should be aware that a failure to set out the basic information, if it's not fatal to the impecuniosity plea, it might result in an adverse cost order. And finally, defendants we may see considering asking for similar directions in respect of impecuniosity, like the reply to the defence that some courts are already doing, and that we have in this case. So moving on then, second issue to look at are some recent developments on credit cards, and to what extent should the claimant be expected to use credit that's available to them, especially in cases where they don't have very much cash in their bank account, but they do have some left until they reach their credit card limit. To what extent can they be expected to foot the bill on the credit card and wait to be repaid? And there's a bit of a difference of approach between judges. Some judges are a bit more sympathetic to that kind of submission, and some are a little bit more unwilling to expect a claimant to spend lots of money on a credit card. And these cases, looking at that kind of thing, deal with the broader issues that what actually needs to be funded. Is it just the hire, or is it the hire and the repair of a vehicle in this notional exercise that we have to undertake? And which resources do they have to draw on? So again, just some basic principles. The two sort of basic authorities on credit cards and whether they can be considered, Lagdon and O'Connor. Lord Hope said that actually that's pretty much the test. In practice, the dividing line is likely to lie between those who have a credit card and those who don't. Not many judges will follow that as being the hard and fast test, because most people have credit cards, and it doesn't necessarily mean that they have enough money to fund large outgoings. And in fact, that was recognised in the later case of Patney and First Leicester buses. The Court of Appeal rolled back from that being the test. They said in practice, whether someone's impecunious will depend on the facts of a particular case. And Lord Hope's rule of thumb test is not necessarily determinative of the issue of whether a claimant can afford to pay higher charges day by day, which is the key question. So it all depends on the facts. A few years ago, when I was just starting out, a case that was fairly regularly referred to in support of the claimant's position was Care and Toll, which is a Northern Irish High Court decision, which had to consider whether the claimant should be ordered to produce their credit card statements and various other things as well. And the Northern Irish Queen's Bench said that they shouldn't have to provide disclosure of their credit card statements for various reasons. They said that if you spend money on a credit card, then you can't spend it on something else, which I don't really understand, because that would seem to apply to any funds, really, not just a credit card. But they also said there's various complications with a credit card. You'd have interest running as soon as you spent money on it, and if you weren't able to pay it off, then that would have an adverse impact on your credit rating. And so that was every so often cited in support of the fact that courts should simply disregard credit cards altogether. In my view, there's a fairly extensive body of English cases, English authorities that support the opposite view. So all these cases, Lagden and O'Connor, Zurich and Umergy, Opoku and Tintus, and then two more recent cases, Hayder and DSM, and Putta and RSA, all say that credit cards should be looked at by the court as part of the claimant's available means, albeit it's a fact-sensitive exercise. One fairly recent case that is now, I'm sure you're all familiar with Irving and Morgan Sindel, and it's now fairly routinely cited in support of the claimant's position when it comes to impecuniosity. Obviously, the main issue in that case was an enforceability argument. There's a section at the end of the judgment where the High Court judge deals with the judge at first instance's findings on impecuniosity. In that case, the pre-accident value of the vehicle was only £775. And His Honour Judge Saffman, who was the trial judge, said that the claimant could raise £900 by spending all her money and then maxing out her credit card. And then if she did that, she could just replace the vehicle so she could have avoided the hire charges. And the High Court judge said that was wrong, the wrong approach. She would have had to spend the money on the pre-accident value, but then she would also have had to have 4 weeks of hire. So she couldn't just replace the vehicle straight away. She'd have had to wait for it to be written off, and then she'd be entitled to another 2 weeks to replace her vehicle. So when you factor in what she'd have had to spend on hire, as well as the pre-accident value, there was no way she was going to be able to afford that total bill. Just on whether it's both repairs and hire, or whether you're just looking at the hire, I think there's certainly room for argument for both positions, and I don't think there's an authority that actually covers all situations. It probably depends a little bit on the particular credit hire arrangement. It depends on what information, what evidence you have before the court. So if you want to argue that a credit repair agreement would not have been available to the claimant if they hadn't also signed up to the credit hire agreement, then that needs to be put in evidence. You need the terms and conditions to be able to show that. You can't expect the court just to assume it, albeit some judges might be persuaded to do so. But it all just depends on the facts, depends a little bit on the judge, and I can see arguments both ways. The defendant might respond that in actual fact, what a pecunious claimant would have done would be simply to claim the repair cost on their insurance. But then in response to that, the principle that's well established in law is that insurance benefits cannot be paid in aid of the defendant's position. So the defendant might encounter difficulties there. So I don't think there's any definitive position about whether we always have to consider the repairs and the hire, or each individually. But returning to Irving and Morgan Sindel, the quote at the end of the judgment, which I'm sure you've heard before, is, "I cannot ignore the fact that by reducing her capital to the bare minimum and increasing her debt, the claimant would have been exposing herself to the risk of a serious financial challenge in the event that even a modest but unexpected financial reverse might have afflicted her before the claim was satisfied. Impecuniosity need not amount to penury. Now, I think it is a fair point to say that Mr. Justice Turner was responding to His Honour Judge Safman's suggestion that she should actually extend the credit on her credit card. So it's in that context that he made those comments. But I think most trial judges would be persuaded that what this paragraph is really saying is that the claimant can't be expected to reduce their available funds to the absolute minimum, so that if something unexpected came up, they just simply wouldn't be able to pay for it, and they'd be in financial difficulties. And I think that's probably the approach that most judges would have followed even before Mr. Justice Turner made these comments. The trial judge's approach reminds me a little bit of this meme. When you're for the defendant and you're suggesting that the claimant should spend sort of the £50 in their bank account on repairing the vehicle, and then sort of top that up with the remaining money they have on their credit card, it's a weaker argument for the fact that they're pecunious than if they have the cash in the first place. Having said that, the final case on this issue of dipping into credit is a fairly recent case handled by Aidan, who's at Farrar's building, and it's Putter and Royal Sun Alliance. And this case is an example of where the court has been willing to apply a more stringent approach against the claimant. In that case, the trial judge found that it wasn't reasonable for the claimant to wait until the defendant had responded to the engineer's report before they took steps to replace their own vehicle. So the judge said that they should have allowed 15 days in line with the pre-accident protocol, and then they should have started to look to replace the vehicle. It was, I've said the defendant, I meant the claimant, could be expected to use credit cards. So again, that's consistent with the other authorities I mentioned, that credit cards are available for use and should be looked at by the court. But the judge also said that there were available funds in the bank account. They did also consider short-term borrowing from tax savings and also short-term overdraft usage if it dropped below the minimum for a short period of time. Said that the claimant could essentially take a week-by-week view on what needed to be spent, and with all these things at his disposal, could have been able to fund basic hire rate for a short period of time until they repaired their own vehicle. Irving and Morgan-Sindall was considered, and the High Court judge said that it wasn't a penury type situation like Irving and Morgan-Sindall. Even though there were quite stringent expectations of the kinds of cash that had been put aside that he might be expected to dip into, and the extent to which he'd have to use his credit card to cover any shortfall. So that's an example of a more stringent approach, and a very clear case where it was said the claimant should be expected to use his credit card. Finally, just a couple of more minor topics as we round off. Taxi claims. There's been a fairly recent decision called Hussain and EUI, and that really sets out the approach that now is to be taken, where the car that's been damaged is a profit-earning vehicle, something that's used as a taxi or to earn money at work. And it said that generally speaking, the correct measure of loss is the loss of profit that the claimant would have incurred in that time. But that's subject to 3 exceptions that the court laid out. Firstly, if the business has to continue during the time that the damaged vehicle is off the road in order to retain important contracts and customers. Secondly, if there's some private use as well as business use, then the claimant is entitled to hire another one on the normal basis. And then thirdly, where the claimant can't afford to stop working, even for a couple of weeks. If they live hand to mouth, they need a constant flow of cash to fund their bills and their daily living, then they'd be entitled to rent a vehicle, even if it's at a loss. But very important is these additional comments. It's the normal approach to proving impecuniosity in these cases. If a taxi driver is saying, I couldn't afford not to work, then just like any case where impecuniosity is being relied on, they need to comply with the court directions. They need to provide financial disclosure, and they need to set out the facts as to why they couldn't afford to rent or not to work. The court said even where the claimant's income is low, the court will not simply accept an assertion that he or she could not afford not to work without proper evidence of impecuniosity. So in a similar way to Dirier and Bojaj, that statement is affirming a need to actually go beyond a bold assertion of impecuniosity and actually to show some evidence as to the financial position. Finally, the last case we'll look at is a recent case on fundamental dishonesty, where that's related to the plea of impecuniosity in the credit hire claim. So it's a case of Hayder and DSM. The claimant in that case had failed to disclose a bank account and 2 credit cards. And then when asked about what bank accounts he had, he then, in part 18 questions, he said, I did not have any credit card accounts. And he signed that with a statement of truth. So a very clear statement. And then he was cross-examined on this. And actually it came out that not only did he have another bank account, but that was the bank account that the pre-accident value check was paid into. And he had 2 credit card accounts. He said they were closed, but the judge on appeal said that the explanation that he gave was simply not credible. The judge on appeal said that that failure to disclose the credit cards and the additional bank account was deliberate, and he had been dishonest in his failure to disclose. That dishonesty, and this is probably the important point, is that particular dishonesty amounted to fundamental dishonesty, because the evidence in support of impecuniosity went to the root of the claim, because it's a substantial part of the overall sum that's being claimed, is the difference between the position if he's impecunious and if he's not. This isn't authority to say that any failure to disclose is dishonest, let alone fundamentally dishonest. The test for dishonesty requires the court to consider the claimant's state of mind, so what they actually knew compared to what they said, and whether that's dishonest by the objective standards of decent, honest people. And the court considered that test. They considered all the circumstances, everything that the claimant had said, and particularly the statements of truth on the Part 18 questions, and concluded in those particular circumstances that the claimant's not being forthcoming was actually deliberate and dishonest. So in the right case, particularly where questions have been asked and there's been a repeated failure to produce the documents, it might amount to fundamental dishonesty. So that should be a particular, something that claimant advisors should take particular care of, and something that defendants may want to inquire into if it's that kind of case, and a helpful authority to know about in those circumstances. So thank you very much. That concludes the webinar, really. I've seen on the Q&A that I have 2 questions. So I'm just going to read them out so that everyone gets the benefit of them, and I'll have a stab at answering them as best as I can. So first question we have is from Flora, and it says, does credit hire have any place at a stage 3 hearing where hire is significant but no evidence was filed at stage 2, re-impecuniosity, need, length of hire, etc. The defendant is unable to produce rates evidence. Can the defendant rely on the district judge always making special directions pre-stage 3 hearing or pushing it into part 7? The defendant is in trouble if they haven't raised issues as to period, rate, need, etc. at stage 2. The best thing that a defendant can do in those circumstances is ask for it to be transferred to part 7, and then they'll have the costs associated with litigation. So that's the trade-off. In terms of if you end up and you have raised some issues, you're able to make those points, and the defendant is the evidence is incomplete. Maybe we don't have particularly good impecuniosity evidence. I think there's a range of approaches. It depends a little bit on the judge. So some judges would be more willing to say, well, the claimant hasn't set out their stall in enough detail, so they've failed to discharge the burden of proof. Other judges would be willing to say, well, this is a more rough and ready exercise in the stage 3 procedure, and I'm willing to just look at the information we have and conclude that the claimant was probably impecunious. So if the defendant wants to have the evidence considered properly and rigorously, I'd certainly avoid the stage 3 procedure. But if you end up there and haven't raised any issues, then there's not a lot that the defendant can do. Feel free to come back on me if I haven't answered or got to the nub of the question, by the way. But I'll move on. So Matthew's asked, I accept the point that insurance arrangements like donations cannot be paid in aid to reduce the tortfeasor's liability, Hunt and Severs, but there's a valid distinction to be drawn between tortfeasor relying on insurance arrangements to reduce the liability and calculating the claimant's recoverable damages after taking account of a breach of duty. That is, a reasonable person would have used their comprehensive insurance. Yeah, fair point. I think that's perfectly arguable. There are no cases in the credit hire context that say that. I think Zurich and Umergy, right at the end, there was a similar argument that was going to be run, but it wasn't dealt with on that occasion. So I'm not going to say that's wrong. Equally, I'm not going to say it's definitely correct. It's simply untested, and I think perfectly arguable. We're beginning to see, as Peter asked, we're beginning to see disclosure of summary documents from claimants to show the financial position without the detail. How do you feel about this? And do you think there's any likelihood of the court adopting them rather than the standard order for 3 months of everything? My view would be that the court is unlikely to change the standard order because that gives the defendant the opportunity to cross-examine. So the reason for requiring disclosure of absolutely everything, bank accounts and all, and wage slips, is twofold, I suppose. One, so that the claimant, there's a clear standard that the claimant has to meet to discharge the burden of proof. And two, the defendant, just in the interest of fairness, is able to analyze the documents and make points in cross-examination to challenge the plea of impecuniosity. So if a claimant simply discloses a summary and it has some of the relevant information, I think that could be very helpful. And a lot of claimants wouldn't go that far, but I think that's a good approach. But I think also, just in the interest of fairness, I think most judges would still be requiring them to disclose the actual documents to prove impecuniosity and giving the defendants a chance to respond and challenge the assertion. I've never come across one of these summaries, so I'd be interested to see if any of my cases in the near future involve something like that. Emma asks, I have rates with a hire company where claimant solicitor has said the company only takes payment for hire with a credit card which their client doesn't have, so we can't rely on this rate. It's the only rate too. Any ideas to counter this? I think again, there's arguments either way. You could say it's a notional exercise. So as long as your rates evidence gives you as long as it's evidence sufficient for the judge to infer the cost of hire on the open market, then you don't need to descend to the nitty-gritty of whether the claimant could or could not have hired it. But then the claimant will argue back that it needs to be an option that's available to the claimant. So I think there's arguments either way. What kind of wording would you put in proposed directions for reply to the defence to ensure you get specific directions in line with Dirier and Beaujage? I think you could do no better than to copy the order that's actually referred to in that case. So in the case, there was a fairly stringent direction saying that the claimant must set out all facts in relation to impecuniosity. Otherwise, they're debarred from relying on impecuniosity. Now, if you're for a defendant, then that's a dream, because they need to set out their whole stall at an early stage in the proceedings, and if they don't come up with the detail, then they'll fall foul of that order. So you could aim for something like that. It's a case management order, so the judge will be allowed to reject that approach and do what they feel is reasonable. They might say the claimant needs to provide something short of all the facts, but at least a summary. And you could also suggest the detail that they have to provide, like the income, outgoing, credit limits, and any particular facts. Something like that, the court might be persuaded to order. Next question: when the claimant fails to comply with directions regarding impecuniosity and there's no automatic debarring order, do you think it's best to make an application to debar or instruct counsel to challenge or raise that at trial? Good question. I mean, if you're on the small claims track, there's no point making an application, interim application. Just do it at trial. If you're dealing with something bigger on the fast track or the multi-track, I think in general it's a point that can be taken at trial. I think most judges would be. I can't think of a case where it's been a problem that a separate application hasn't been made to deal with the question of whether the claimant's debarred. I think that's something that's normally dealt with on the day of the trial. I would normally deal with it as a preliminary issue before going on to consider the evidence. Sorry, yeah. So returning to your actual question, if there's no debarring order, then there's no basis to argue that they are procedurally debarred from relying on it. So really, it's just a matter of instructing counsel to argue that there is a clear standard, and Zurich and Umergy is the best case for this, that even without a debarring order, just the standard that they need to meet to prove their impecuniosity requires disclosure of all the relevant documents. So if there's no debarring order, you can't argue that they're not allowed to try and persuade the court that they're impecunious. It would be a question of the evidence and the submissions about the normal level of evidence that they should provide. Rekha asks, what if the claimant says later on in proceedings that they've forgotten about certain bank accounts or credit cards and disclose the details close to trial? Is there likely to be any consequences? I mean, the orthodox position is that if disclosed it in line with the order, then they're debarred by virtue of that paragraph of the directions order. So they need to apply for relief from sanctions. And if they haven't actually made an application by the date of the trial, then the court may not entertain that. Having said that, some judges, and particularly on the small claims track, I would say 9 out of 10 judges, if they haven't disclosed something by the time of the trial, will not entertain an application for relief from sanctions. If you're on the small claims track and they've provided the disclosure a few days before, I think most judges would actually allow them to apply for relief and to rely on the document. If you're on the fast track or the multi-track, I think they'd need to make a Part 23 application for relief. And if they hadn't done so, then they wouldn't be allowed to rely on that evidence because it hasn't been disclosed, and they'd be debarred. So I hope that answers your question. I think that's all the circumstances. If it's late, then they're technically in breach. But depending on whether you're on the small claims track or the multi-track, judge may take a more or less lenient approach to them being allowed to rely on that evidence. Great. Well, I think that's all the questions that I have in the box. So unless there's any other late ones, then we'll wrap up there. Thank you very much for attending, and my email is on the slide, so do feel free to get in touch about anything, and I'll do my best to field any questions you have. But I hope you find it helpful, and I hope you've enjoyed it, and have a nice evening. Bye.